Hello, I'm here this morning with Jeremy, and we're going to talk a little bit about some of the issues that have been coming up for our clients in terms of the impact of the Equality Act and anti-discrimination legislation more generally on commercial companies when they're providing services.
That's an area that is quite well established on the public sector side, and commercial companies sometimes overlook that there are a range of obligations that can apply to the way they deliver products and services.
Yeah, it's interesting, isn't it? Because we do very much think about it in that area, but actually any commercial company that provides a service is caught by the Equality Act, even if that service is for free. So it means they need to think about the impact of what they're doing on people with what's known as protected characteristics. So that's things like race, religion, disability, and make sure that they are not discriminating either directly or indirectly against those people. The thing is, because this is maybe thought of as a bit more of a public sector thing, there isn't a lot of case law in this area about what that obligation really means in practice. We do have one example when the RNIB brought a case against BMI Baby in relation to their website. They said that it was inaccessible to blind people. Unfortunately, the case settled, so we never actually got to hear what the court had to say about that issue. So do you have any suggestions in the absence of much case law? You know, where should companies look?
Well, I think the BMI Baby example is a really good one because it shows how in every sector consumer groups, groups focused on particular protected characteristics are really focused on the reputational impact that not addressing these issues can have on businesses. And I think that is a great first place to look and to think about how your products and your services are catering for these obligations in a way that doesn't damage your reputation in the market. And the converse is also true. If you are seen as a leader in this area, you're also more likely to win market share from people with those protected characteristics. So it cuts both ways. Another area that I think is really interesting in this space is are the licensed sectors, the regulated sectors, which people don't often think about, but have a strong consumer focus. So I'm thinking about the electricity and the gas supply industry, train operators, the rail industry, all of the businesses providing services in these areas are heavily regulated, have licenses, and those license conditions frequently focus on vulnerable consumers, passengers who have with reduced mobility, who are disabled, and looking at the practice and the way that those companies comply with their license conditions in these areas can give really strong guidance to businesses across a range of sectors about how to comply with their equality obligations.
Yeah, absolutely. And I can see that a court, when perhaps they're starting to think about, well, what should those obligations look like in practice, would be very interested to hear evidence of what's coming out of those regulated sectors as to sort of guide their thinking. The other thing that's interesting is the EU has decided to bring in a new directive to harmonise things in this area. So they are bringing in, or have brought in, an accessibility directive, which doesn't apply to all products and services, but the application's quite wide, particularly in the technology sector, so it covers e-commerce, for example. And these obligations, so the directive sets out some hard obligations, but also in the annexes a lot of examples of how this could be done in practice. And again, even if you're not actually caught by the directive itself, you can foresee that a court, when looking at an Equality Act obligation, would be very guided by those annexes to the directive. So it's definitely worth bearing in mind, regardless of whether you're caught. Of course, if you are caught, the directive will come into law in 2025, and it's a good idea to establish, if you are caught now, so that you can start designing products and services to be compliant from day one, rather than having to sort of redesign later on. Jeremy, do you have any other recommendations?
I do. So as well as the licensed regulated sectors, it makes sense to look at how the public sector approach their duties here. So they have a broader duty, a public sector equality duty, which broadly translates into them undertaking a quite detailed analysis against each of the protected characteristics when there's going to be a significant decision taken or a significant new policy introduced. And you can see quite easily how that type of analysis actually could be used far broader than the public sector in product design, in rolling out new services. So I think that's a really good place to look as well. And the other place I would suggest is the regulatory guidance and regulatory case law, actually, in the various sectors that I've mentioned.
Yeah, absolutely. Well, thank you, Jeremy.
Thank you.
It was good to talk to you, and we'll be back soon for more in this area.
Yes.